Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Dempsey, and thank you to counsel for being available for the hearing this morning. We will conduct the hearing in the same fashion as if all of us were in the courtroom together. Each party has 15 minutes. Well, the appellant and the appellees each have 15 minutes to argue their case, and the appellant has already reserved 5 of that time for a rebuttal. Now, I see that there's 3 of you. Will there be any time sharing, or is it just 2 of you arguing?
Just 2 arguments, Your Honor.
Very good. All right. Well, unless there's announcements, please call the case.
In re TWT Acquisition, LLC.
All right. Ms. Pulley, you have the floor. Ms. Runyon, I should say.
Okay, thank you, Your Honor. My name is Markley Runyon. I am a member of the Montgomery County Bar Association, also currently practicing in Houston County. I did file this appeal, and without trying to make this complicated, it's actually not a complicated issue. The focus of the appeal is on TCA section 5-2-115, particularly subsection D. What this appeal involves is a building within the industrial park that is owned by both Stewart and Houston counties. The deed is actually recorded in both Stewart and Houston counties, and it's also further governed by an industrial agreement between the counties. In 1997, there was a business that came to be that was prior to the current taxpayer that initially filed the appeal. And since 1997, Houston County was the taxing authority for this property, for both the real property and the personal property. The important thing to note is under the industrial board agreement, the 2 counties actually share the real property taxes. In other words, even though Houston County is the taxing authority, we share 50% of the real property taxes with Stewart County. We do not share the personal property taxes, and that's the way it has been since 1997. At some point, unbeknown to Houston County, Stewart County decided they would also begin to tax the personal property of this business as a taxing authority. Houston County was not aware of that until the taxpayer filed this appeal. It was brought to everyone's attention at that time. We presented this to the administrative law judge, Brooke Thompson, and Mr. Thompson found that under 5-2-115 subsection D, it clearly says that where property has been taxed in one location for more than 5 years, it should not then be taxed regardless of location by a different county. And the reason why this is so important, there are no cases that interpret that subsection D of Tennessee Code Annotated. But the reason it becomes very important is because you've got 2 county governments with taxing authority. And when the county government develops their budget, their plans for the year, they count on what money is coming in from those taxes. And certainly when this issue came up and there was a repayment that was obviously due to the taxpayer, it caused quite a bit of chaos. Perhaps it could have been prevented if the counties had discussed a change in the taxing authority on the personal property. But it's very unusual in that Houston County had always taxed the property and then Stewart County began to tax it. The one thing I can say, I do agree with the state of Tennessee and the AG's office on the fact that on initial assessments, it's very important for both of the taxing authorities to actually look at the location of where the real property is and where the personal property is. And that should be the proper authority to tax that. I don't disagree with that on an initial assessment. The reason this is different is because this is not an initial assessment. This is something that has gone on since 1997, and suddenly Stewart County decided to change it. Therefore, I feel like subsection D in the code clearly addresses it. And the reason that's important is it prevents the problem that we've now created in this very case.
What, Ms. Runyon, what if that personal property were moved to Shelby County?
Well, then it shouldn't be taxed in Houston County any further.
Well, what if it was moved from, what if it was moved to a building in Houston County?
Well, then I would assume the business, Your Honor, would have also have moved.
Well, no, a personal property can easily be moved. You call a U-Haul or call a moving company or tell all your employees to bring their biggest vehicle and you put the stuff in their cars and you drive away.
That's correct.
Real property doesn't move, but personal property does. So why should we say that personal property the taxing authority should never change?
I think that the taxing authority can change, Your Honor. In this particular situation, you've got a deed and a building that sits within two different counties. It sits partly in Houston County, partly in Stewart County. Exactly where the line is, I'm not sure. There's been references to a survey. Actually, I've looked at the record. There's not a survey that's been done by either county on this. If you look at the mapping that was introduced at the Board of Equalization, which mapping is not a survey, there is some mapping, and you can go on the Tennessee State website and look at mapping and say, well, maybe more of the personal property is in Stewart County. The fact of the matter is, this was always considered a Houston County business. The deeds were recorded as such. The taxing authority was assessed as such. It's just a very odd situation in that the actual property itself is in both counties.
But as a policy, under your interpretation of 115D, what you would say is, it seems like to me your interpretation of that statute will create a fair amount of havoc because you care less about where the personality is actually located than you do about who taxed the personality for the preceding 5 years. I mean, in response to Judge Clement's questions, you were just saying, well, if the property personality moves to another county, then that other county would tax it. But why wouldn't a county say, well, under 115D, we taxed it for the prior 5 years, and now it can't be taxed in any other county to which it moved?
I don't think that that's applicable, Your Honor. I don't think so at all. This property has not moved anywhere. This property has been in the same location since 1997. Nothing has changed about this property. I do believe.
But we've got to anticipate, though, what the interpretation you're urging on this court, how that will impact other situations. And so we've got to anticipate that there might be a case, and I suspect it often does occur, where personality moves from one county to another. Isn't that, I mean, you seem to acknowledge that that may happen.
I do. And that's where I go back, Your Honor, to an initial assessment. On an initial assessment, certainly the situs, the actual location of the property, is the most important thing for the assessors to look at. So if the property actually moves, then where it moved from would have no further authority. Where it moved to would have new authority.
Even under your interpretation of 115 subsection D.
Yes, Your Honor.
What are we to make of the fact that Part 2 of that title deals what seems to be exclusively with realty?
I'm not certain I understand your question, Judge.
Well, 115 appears in Part 2 of Title 5, correct?
Correct.
And Part 2, to me, seems to deal with realty on the whole. But you're saying this one part of 115D actually deals with both realty and personality. And should we care about that the remainder of the part deals with realty?
I think what's the most important thing is to avoid the confusion for double assessments in the future for similar properties. This property's not moved. It's not been relocated. It's been the same. And That's why I think that it should also apply to the personal property in this particular situation and in all situations that fall in this category.
One of the points that one of the first issue you raised before the statutory construction issue is with respect to where this personally is actually located. And the state has argued that that issue was waived below. What's your response to that argument?
My response to that argument is the only evidence presented to the Board of Equalization was some mapping done by the state of Tennessee. I certainly cannot rely on mapping when I prepare a deed. I certainly cannot rely on mapping when I'm transferring property. So the mapping is helpful to find boundaries and locations, but I don't think it's controlling.
Can you tell me where in your petition for writ of certiorari you raised the issue of the location of the property, personalty?
Your Honor, I can't, and I don't think that I actually did. I really don't. I know the personal property has never moved, just like the real property has never moved.
All right. Thank you, Ms. Runyon. We'll hear from you on rebuttal, Mr. Parks.
Actually, Your Honor, I'm speaking for the two of us.
Forgive me. I had Mr. Parks down. Please proceed.
Not a problem, Your Honor. My name is Joseph Longenecker, and I'm representing.
Mr. Parks just breathed a sigh of relief, I think.
Well, you know,
a heartbeat there real quick.
We can still ask him some bone-crushing questions after.
Yes, sir.
Always an option. My name is Joseph Longenecker, and I'm representing the State Board of Equalization. Similar to what Mrs. Runyon said, this is a pretty limited, this case is of pretty limited scope. What we're dealing with is the interpretation of one statute and whether or not it applies to, and the scope of the word property in that statute. The statute, of course, being 52115, which deals with the use of a particular remedy by the State Board of Equalization, that the State Board is given the power in 52114 to determine county boundaries in the various cases where a county boundary might be legally relevant. 52116 says stipulates how to use that power in cases that aren't assessment cases. And then 52115 says, okay, in an assessment case, though, we want to have these additional procedures. So 52115A says that has a conjoined condition for when 52115 applies. If the county boundary is in question and two different counties have assessed the same piece of property, then the State Board has the power to determine where the county line is for purposes of resolving that dispute.
Do we have to read 115 and 116 together to conclude that your interpretation of subsection D in 115 is correct?
No, I don't think so. I was just providing the 116 context for further. I think it supports our reading, obviously, but I don't think it's necessary. 115, because again, 115 says, okay, if there's property in, and then 52115B says if the property is fully in one, if the State Board determines the property is fully in one county, then void the other county's assessment. If it determines it needs to be divided, if particularly the acres or amount of property needs to be divided, then the State Board needs to divide it pro rata using the same methods that they would have a county assessor use to determine the value of the property. And then 52115D basically carves out an exception to that normal set of proceedings, that if this is a case where 52115A would apply, but the same county's been assessing it for more than 5 years, then you don't use the proceedings in A, B, or C. You instead just use a first in time rule. Whichever county's been assessing it longer gets to keep assessing it. And for 4 reasons, I think we can determine that property in this statute must be referring to real property. First, there's language in the statute that points to real property, such as acres or amounts. The sort of language that is amount is admittedly a vague term, but if we read it in combination with acres, that covers all of real property. Whereas, there's no language in this that points towards personal property. Similarly, the sort of statute of limitations that is the crux of this case only really works with real property. Again, it seems to assume both the language of 115A and 115D seems to assume that the only thing that's relevant here is where the county line is. And as previous questions indicate, the county line isn't the only thing that matters in a case that deals with personal property, because personal property can move. There's other issues which are dispositive in those kinds of assessment cases. But for a real property case, which county gets to assess it is just determined by where the county line is. And then when we go and move to the second issue is then when we move to the broader statutory context, we see that the rest of Title V, Chapter 2 is focused on these similar issues of real property. It's focused on questions of where the count, like how should new counties register real property within their boundaries? How should how should new counties be set up with respect to their boundaries? These, again, it's a statutory scheme that points towards real property issues, that this is what's in the mind of the legislature. Similarly, when we look at the only statute which refers to it, admittedly a previous version of 52115, it's a statute that's about property maps. It's saying that if the state board used this power to determine where the county line is, it had to go and tell the state board, another division of the state board, hey, you need to redraw property maps. And these property maps are just about real property. There's no stipulation for dealing with personal property. And finally, then, when we look at the statute as a whole, if there's real property, it's clear that this is a limited statute. It doesn't really extend far beyond what we would think. It's like, okay, if there's real property, which is the sort of property which a boundary line dispute between two counties is the question, then these are the proceedings we follow. And then there's a limited carve-out provision if the same county's been assessing it for more than 5 years to prevent massive fluctuations in the tax base, that a county can't go be adventurous and go to the original deeds from the original property records from the 1800s and go and say, oh, actually, we get to tax this because we found something in the basement of the University of North Carolina that says we get to tax it. That it's saying that the State Board of Equalization doesn't have that kind of far-reaching power to revise where the real property lies.
What's the remedy in a situation like that, though, where realty has been taxed and then it's later determined that the surveys were incorrect? Does the county have a remedy?
That's a good question. I'm not aware of a particular remedy that would exist, Your Honor. Historically, the legislature obviously could fix the problem. And again, this statute is only a restriction on the State Board of Equalization. So depending on what other remedies might be available through the courts might be possible. But this is just a restriction on the State Board, not on the powers of the courts. So basically, the use of interpreting this word property as real property here introduces an intrinsic limitation that gives the statute narrow contours. Whereas if we assume that property here means personal property, we have a variety of questions that aren't answered by the statute. We do know it's like, well, wait, how does this 5-year statute of limitations apply if it's a piece of personal property? Like, what happens when it's moved? What kind? And if we're going to say, oh, it's only really immovable personal property that this applies to, not other kinds, like what's the standard for removability? That's not in the statute anywhere, unless we read property to be real property. Then it's in the statute. We don't need to find some sort of extra statutory limiting principle here that would enable us to understand, that would enable us to draw conclusions about when the statute applies versus when the statute doesn't apply. So I do have a few quick responses to some of the points that Ms. Runyon made. I do think that the word property, of course, can, in some context, mean both real and personal property. But I think, as we highlighted in our brief, there's a number of cases where property just means real property. And in fact, especially in cases where boundary lines or zoning or where the word acres is used, often there's no need to include the word real property in those cases to disambiguate. You know it's the kind of property in question. It's real property. Similarly, the sort of concerns about budgetary reliance. Well, I'm very sympathetic to the policy issues that Ms. Runyon raised. The instability in the county tax base here wouldn't be caused by our statutory reading. It's caused by the nature of personal property. It's just an unfortunate fact that, fortunate or unfortunate, I suppose, depending on your point of view, that personal property can be moved. That tomorrow, the personal property in question here, it might be quite expensive, but it could be all thrown into a U-Haul and shipped off to some other state. And that would obviously be potentially quite harsh for the tax that could have like quite negative tax consequences for the counties in question, but it could still happen. There's nothing that prevents it from happening. So that kind of instability can't be mitigated by this rule, unless we were to read it in a very expansive way that would raise other problems that have already been highlighted. So yeah, so for those reasons, I think that we should uphold the ruling of the Chancery Court.
The parties in this case, Stewart County and Houston County, have other remedies on this type of dispute, for example, Chancery Court in an independent action, or does it have to come through the Board of Equalization?
That's a good question, Your Honor. I don't entirely know the answer to that. I would assume the particular question of where they can determine the county boundaries, at least in this, where there's these two assessments, is that I think that would be first before the Board of Equalization, but I'm not entirely sure, Your Honor.
But if it's a dispute as to which county may tax, then that comes before the Board of Equalization.
I would, yeah, I mean, if there's two, actually, I guess specifically if there's two assessments in question, it certainly would. I'm less certain what would happen if in a case where where it was just a general request for a declaratory action.
All right, thank you. Anything further?
No, I'm happy to
questions from
concede
the
the rest
panel?
of my time.
All right, then we'll hear a rebuttal from Ms. Runyon.
Judge Clement, real quick, to speak back to what you were saying, it might be helpful to remember that this appeal did not come from either county. This appeal came from the taxpayer himself when he realized that his bookkeeper had been paying personal property taxes in two different counties. It came through on one of their audits. It didn't originate between the two counties. The two counties had been operating just fine under their industrial board agreement. Houston County had been the taxing authority since 1997. And again, I point out, this is very peculiar. This land and this building lies in two different counties. And I'm sure that this panel is thinking, well, wouldn't it have been helpful for someone to have a survey? Well, I don't know what Mr. Parks would say about that, but when you ask the county commission to spend money on various things, often it's a no. We can't do that. There is no survey that actually shows where the line goes through this building. So how much personal property?
Counsel for interrupting. Is it undisputed that the personal property is exclusively and wholly within Stewart County?
No, that's not undisputed. That's disputed.
That is disputed.
That is disputed. And I would point out there is no survey. There is some mapping from the state that you can look at. But again, we've never conceded that it's wholly within Stewart County. No, sir.
Thank you.
The only other point that I would make is the havoc that this issue did create, because like I said, this was brought by the taxpayer. It was the taxpayer who suffered from two counties beginning to tax, but they were always taxed in one county. The remaining issues are governed by the industrial board agreement, and we do share the real property taxes. So I just don't think that you suddenly change taxing authority after one authority has taxed it for a number of years for the reasons I've already stated.
All right, anything further, Ms. Runyon?
No, Your Honor.
When's the last time Houston County made an assessment of personality within the county?
That would be a question for my assessor, Your Honor. I know that they regularly go out and check things, but that's really all I know.
Any further questions from the panel? Hearing none. Thank you both, counsel, for your arguments, and we will take this matter under advisement. Ms. Dempsey?
This honorable court is in recess until 10 a.m.
Thank you, Your Honors.
Thank you both.
Thank you.
And Mr. Parks, you did a great job.